Okay, let's unpack this. You gave us this stack of sources,
Yeah.
and at first glance, they really look like they're all about one thing,
Yeah.
strengthening border security.
Right.
But as we started digging in, it just became so clear these changes, they reach into so many, well, unexpected corners of life. We're
Exactly.
talking everything from like how your mail gets delivered to financial transactions and, yeah, even how companies you use every day handle your data. It's pretty wide-ranging.
That's really what's fascinating here. We're looking at a collection of legislative text, essentially the proposed legal wording itself, and it's paired with a government news release.
Right.
And that release frames it all under this broad heading, something like strengthening border security and enacting other related security measures.
Ah, okay, okay.
And it's that other related security measures part where things get really interesting because these sources, they detail amendments to a surprisingly wide range of Canadian laws.
Absolutely. I mean, laws covering customs, Canada Post, immigration, anti-money laundering efforts, police powers for getting data,
Yeah, sex offender information registries, controlled substances.
and even creating a whole new framework for tech companies, for electronic service providers.
Right, a completely new act for that.
So our mission, really, in this deep dive is to try and guide you through all this complex material, pull out the essential insights, maybe highlight the surprising connections and, the implications for you.
Exactly. The news release kind of sets the stage. Government of Canada strengthens border security, blah, blah, blah. But what the legislative text really shows us is just how interconnected modern security actually is. It reaches way beyond just the physical border.
Yeah, you can really see that thread. So let's dive in. Maybe we start at the border itself and then sort of follow these threads out to the other areas.
Sounds good. So first up, changes to the Customs Act. The sources detail some new requirements for owners or operators of things like, say, international bridges or tunnels right near the border.
Okay, what kind of requirements?
Well, they'll now be explicitly required to provide and maintain customs facilities right there on site. And, importantly, free of charge to the government.
That seems pretty practical just for border operations. Smooth things out, maybe.
Yeah, presumably.
Is there anything else that jumped out in the customs changes?
There's kind of an interesting clause about previous costs. Basically, neither the government nor the owner-operator can sue each other for costs related to the use of those facilities before these new rules kick in.
Oh, like wiping the slate clean on any past deals or argument about who paid for what.
Sort of, yeah. Wiping the slate clean is a good way to put it. The law's also updated to clarify customs agents' access rights to places where goods are being prepped for export, just making that clearer.
Okay. So moving slightly away from the, let's say, physical border, but still about things crossing it, mail, the Canada Post Corporation Act gets some tweaks too in these sources.
Yes. The text clarifies that mail that's in transit, it can only be seized or held if another specific act of parliament actually allows it. You need explicit authority.
Right. So not just anyone can grab mail. There has to be a law backing it up.
Precisely. And if mail is seized under a law other than, say, the Canada Post Act itself or the CSIS Act, Canada Post generally has to be notified within 60 days. There are exceptions, but that's the general rule.
Okay, so specific legal authority needed, and Canada Post needs to be kept in the loop, usually.
Exactly. What's also kind of notable is the source indicates an expansion of Canada Post's own power to open mail, but only under certain defined circumstances.
Okay. Now, here's where things, I think, start getting into potentially broader impact for individuals. The Immigration and Refugee Protection Act. The changes described here seem quite significant.
They really are. One change allows for new regulations about sharing information that's collected from people under this act, sharing it with other federal departments and agencies.
So information collected for immigration purposes could potentially flow more easily to other parts of the government.
That seems to be the idea, yes. Expanding that data flow is, like you said earlier, kind of a recurring theme here.
Yeah, definitely. But the powers granted to the federal cabinet, the governor and council, they seem particularly broad in this section.
They do. The sources state the governor and council can make orders if they believe it's, quote, in the public interest. And this power is described as allowing them to order that certain types of applications from foreign nationals.
Like what types?
Things like permanent or temporary resident visas, work permits, study permits. They can order that these applications will not be accepted for processing for a specified time.
Wow. So they can effectively just pause processing for entire categories of applicants if they decide it's necessary.
Yes, and the sources also say they can suspend or even permanently terminate the processing of applications that are already in the system, people who've already applied. And on top of that, they can use the same public interest power to cancel, suspend, or change documents that have already been issued, like visas or permits, or impose new conditions on them after the fact.
That is a significant tool for, I guess, managing the flow of people into the country based on what the government sees as necessary at any given moment.
Absolutely. It's a very powerful lever.
Does the source mention any, checks on this power or oversight?
Well, the sources do note these specific public interest orders from the governor and council are exempt from certain requirements that normally apply to regulations under the Statutory Instruments Act.
And that act usually involves things like,
Things like requirements for pre-publication or opportunities for public comment before a regulation comes into force. So some of that is bypassed here.
okay,
However, these specific orders must still be published in the Canada Gazette relatively quickly, the source says, within 23 days. So there are some procedural shortcuts, but public notice is still required after the fact.
right. So transparency, but maybe less input beforehand for these specific orders. Are there other immigration changes mentioned?
Yeah, a few others. They mention that where a person is physically located can now affect how their asylum claim is considered.
Okay.
Also, agents get powers to cancel or suspend documents in certain specified cases, and there's a provision allowing officials to require examinations, including medical ones, for some document holders, even while they're still outside Canada.
Okay. Quite a bit happening on the immigration front then.
Yeah.
Let's shift gears entirely. Let's look at changes affecting how law enforcement and security agencies access information and data. This seems like another big chunk with updates to the criminal code.
Yeah, this is where the sources really show a clear effort to modernize legal tools for, well, the digital age. The criminal code amendments are designed to make it easier for police to get basic identifying information about subscribers.
Like who owns an account?
Exactly. Basic subscriber info from service providers using things like information demands or production orders,
Yeah.
making that process smoother.
And they're also clarifying the legal authority for actually examining computer data during investigations.
Precisely. That's being shored up. And one interesting new process described allows police or other public officers, with a judge's okay, of course, to request transmission data or subscriber info directly from foreign telecommunications companies.
So trying to deal with data that might be stored outside Canada.
Seems like it. And the sources even include, like, the updated forms for warrants and orders to cover these different types of digital data, transmission data, location data, that basic subscriber info.
This really sounds like an attempt to keep pace with how communication just happens globally now. You mentioned production orders. Is there protection mentioned for companies or people who actually comply with these requests?
Yes, that's explicitly stated. The sources specify that people or companies who maintain accounts or preserve data, produce documents, or even voluntarily provide information when requested or required under these specific powers, they are granted civil and criminal immunity for doing so.
Okay, so protection for cooperating.
Sure.
What about CSIS, the Canadian Security Intelligence Service? Are there related changes for them?
Yes, the Canadian Security Intelligence Service Act also sees some related amendments. The sources clarified that these new data access powers in the criminal code don't somehow limit CSIS's existing abilities to collect information. It's additive, not restrictive for them.
Right.
And it also adds similar immunity for voluntarily providing information to CSIS upon request, much like the criminal code change.
Okay. Is there any way for someone, like a company maybe, to challenge a request from CSIS if they think it's improper?
Yes, the sources describe a process for that. An individual or an entity can apply to a judge to challenge a CSIS information order or demand.
Is there a deadline?
Yeah, it has to be done relatively quickly. The text says no later than 5 days after receiving the order or demand or before they're required to comply, whichever deadline comes first. So a tight time frame.
Okay. And we also saw, just briefly, mentions of updated powers for examining computer data and other laws too, right?
Right.
Like for drugs and cannabis investigations.
That's right, it's noted in the sources. Basically applying similar modernization efforts for data access in those specific investigative contexts. Makes sense to keep things consistent, I suppose.
Yeah. And the Sex Offender Information Registration Act, SOIARA. that gets updated too.
It does. The changes include clarifying who exactly counts as a member of a police service for the purposes of that act, and also refining rules around accessing and sharing the information in the registry, specifically for investigating sexual crimes or related offenses.
And there's a connection to the Customs Act here.
Yes, there's a related amendment in the Customs Act specifically to help facilitate this kind of information sharing under SOIRA, presumably at the border.
Gotcha. There was also a very specific, almost footnote-like textual change mentioned for Sawyer in the sources we looked at.
Oh, yeah, I remember that. A small detail, but noted. The word gender is being replaced with sex in certain specific provisions of the Act.
Interesting detail. Okay, let's move to another area that seemed to have really extensive changes outlined in the sources: financial transactions and information sharing. Specifically under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the PCM-LTFA. This feels pretty central to that other related security measures part.
Oh, it's definitely a major focus. Huge updates here. One small but potentially significant change is adding the Director of FunTrack.
That's the Financial Intelligence Unit.
Right, Canada's FIU. Adding their director to the Supervisory Committee of OSFI, which is the main banking and financial institution regulator. The idea is to allow them to exchange information more easily.
Okay, better coordination. A clear prohibition that jumped out was against anonymous accounts.
That's right. The sources make it absolutely mandatory to identify clients, and they define an anonymous client pretty clearly, basically. Someone whose identity can't be properly verified using the required methods, or if the name they give is obviously fictitious.
Right, no more mystery clients. And there's a new requirement for entities that handle these kinds of financial transactions to actually register with NTRAC.
Yes, a big change. The sources introduce a mandatory enrollment requirement for most types of financial entities covered by the Act: banks, money services businesses, casinos, and so on.
How does that work?
Well, it involves an application process and renewals. And FinTrack gets powers to ask for clarification on applications, and importantly, they can revoke that enrollment if the entity doesn't provide the required info or meet standards.
And FinTrack is going to create, like, a public list of these enrolled entities.
That's what the sources say, yeah. FinTrack will establish and maintain a public registry containing identifying information of all these enrolled businesses. Transparency measure, perhaps?
And they also have to keep records for longer.
They have to keep the verified client identification information for 10 years, according to the source text.
Okay. Information sharing seems to be expanding here, too, beyond just the financial regulators.
Correct. FinTrack gets a new power here. They can now share relevant information with the Commissioner of Canada Elections.
The election watchdog.
Exactly. If FinTrack has reasonable grounds to suspect the information relates to investigating or prosecuting offenses under the Canada Elections Act, so connecting financial intelligence to potential election finance violations.
Interesting link. The rules around penalties for not complying, you call them AMPS, administrative monetary penalties, those are getting a significant overhaul, too.
Yes, quite detailed changes. The sources detail how violations will now be classified as minor, serious, or very serious.
Okay.
And they outline the criteria for setting the penalty amounts. The emphasis is that they're meant to be non-punitive. The goal is encouraging compliance, not just punishment. They have to consider the harm caused by the violation and also the entity's ability to pay.
But the maximum penalties can be quite high.
Oh, yeah. Very high, potentially. The sources set maximums, depending on the violation severity, that could run into millions of dollars, or even a percentage of global revenue for very serious violations by large entities. There are even higher maximums mentioned for failing to follow a compliance order.
Wow. And there's something about a mandatory compliance agreement process after a violation.
Yes, this is new. The sources state that after certain prescribed violations occur, the entity must be required by FinTrack to enter into a compliance agreement. It's not optional.
And what if they refuse, or they agree but don't follow through?
Then FinTrack shall issue a public compliance order. This order would require the entity to take specific actions to fix the problem, and it's public, which adds pressure.
Can entities fight these decisions, like appeal the violation classification or the penalty or the compliance order?
Yes, the sources grant a right to appeal. Decisions about serious or very serious violations or compliance order violations can be appealed to the federal court, but they have to do it within 30 days.
Okay. There are also updates mentioned to actual criminal offenses under the PCM-LTFA.
Right, reinforcing the criminal side. Notably, the sources highlight a specific offense related to knowingly providing false or misleading information or deliberately withholding material information when it's required by the Act.
And the consequences.
Potential fines and imprisonment, according to the text. So, serious consequences for deliberate deception.
Okay. And here's another section under PCML-TFA that felt, well, quite significant. A brand new Part 1.2, regarding the collection and use of personal information.
Ah, yes, this is potentially very impactful. What the sources state is that entities covered by the Act, so banks, financial institutions, etc., they can now collect and use an individual's personal information without their knowledge or consent, but only under very specific conditions.
Without consent. That sounds like a major shift. What are those conditions and, I guess, the allowed purposes?
So, the conditions are key. The sources say the information must be disclosed to the financial entity by specific prescribed government or law enforcement agencies, the RCMP is mentioned, among others.
Okay, so the info has to come from authorities first.
Right, and it can only be used for very specific purposes. Detecting or deterring contraventions of laws related to money laundering, terrorist activity financing, or sanctions evasion. Strictly limited use case.
So just to clarify, if police or certain agencies suspect someone is involved in, say, money laundering, and they share some personal info with a bank related to that suspicion, the bank can then use that info internally for detection purposes, even if the person never consented to the bank having or using that specific piece of data.
That appears to be exactly what the sources indicate, yes. It allows proactive use of intelligence shared by authorities for these specific anti-crime purposes.
Is there immunity for the banks here?
Yes, there's immunity mentioned for entities who act in good faith under this new part, but crucially, the text also explicitly says they cannot use this information with the intention of actually hindering a criminal investigation. It's for detection and deterrence, not interference.
Right. Okay. Well, this leads us, I think, directly to the final, entirely new piece of legislation detailed in the sources. The Supporting Authorized Access to Information Act. This isn't an amendment, it's a whole new law.
Exactly. Brand new. And it's specifically designed to create a framework for electronic service providers, ESPs, so think tech companies, social media, telecom providers, online services.
Okay.
A framework to help authorized persons, meaning police or CSIS, with legal authority under the criminal code or a CSIS, to effectively access information they're lawfully entitled to.
So this is about putting direct legal obligations on tech and online service companies to assist law enforcement and security agencies.
Yes, that's the core purpose. The sources give the Minister of Public Safety very broad power to make regulations. These regulations can require ESPs to actually build specific technical capabilities into their services.
Build them in.
Yeah, to build in capabilities specifically to assist with lawful access requests. And these regulations could even differentiate, maybe based on the type of service offered, or perhaps the number of Canadian users a provider has.
So potentially bigger obligations for bigger players.
Potentially, yes. And the minister can also issue specific orders directly to individual companies.
Like telling one specific company they need to do something.
Exactly. The sources describe the minister issuing ministerial orders to specific ESPs, requiring them to comply with certain provisions of the Act or regulations. However, and this is really important, the sources mention a crucial limitation.
What's that?
An ESP does not have to comply with such an order if doing so would require them to introduce what the text calls a systemic vulnerability into their security, or if it would prevent them from fixing an existing one.
Okay, that sounds like a really critical balance point. They're saying, yes, you need to help us get legally authorized access, but not if the only way to do that is to basically break your own security in a way that could harm all your users or be exploited by others.
That seems to be exactly the tension it's trying to navigate, requiring assistance but drawing a line at creating fundamental security flaws.
Interesting.
And the sources note these ministerial orders, like the immigration ones, are exempt from some procedural steps, but they must be published. And the ESP has to be given a chance to make representations before an order is finalized.
How will the government make sure companies are actually complying with this new act? Enforcement.
Yes, there are enforcement mechanisms. The minister can designate people inspectors to verify compliance. These inspectors can enter facilities, though they need a warrant for private homes, to examine relevant documents and data.
And they can issue orders too.
They can issue compliance orders requiring specific actions from the ESPs if they find non-compliance.
And administrative penalties, like under the PCML-TFA, apply here too. for noncompliance.
Yes, the sources mention administrative penalties can be imposed, but again, they clarify that if a company faces both an administrative penalty proceeding and criminal charges for the exact same act, only one path can be pursued. You can't be penalized twice for the same thing through both systems.
Okay, double jeopardy protection there. If a company wants to challenge one of these ministerial orders or decisions in court, is there a specific process mentioned?
Yes, there's a procedural step. The sources require an ESP that wants to seek judicial review of an order or decision under this new act to give the minister at least 15 days written notice before they file the court action.
A heads-up requirement. And is there any mention of reviewing these rules over time? Technology changes so fast.
Yes, the minister is required to conduct a review. Every 5 years after the first regulation is made under this act, the minister must review all the regulations. And the sources explicitly say this review must involve consulting stakeholders, including provincial attorneys general, and, importantly, the affected ESPs themselves.
Okay, built-in review cycle. Finally, just to cover all the bases, the sources also included some very specific updates to the list of controlled substances.
Right, that was tucked in there too. The sources detail additions to Schedule V of the Controlled Drugs and Substances Act. These include adding substances like carisoprodol, which is a muscle relaxant sometimes abused,
Okay.
and also specific precursor chemicals, things like phenylbromide, propanol anhydride, and benzyl chloride. These aren't drugs people use directly, but they're chemicals often used in the illegal manufacturing of other drugs like methamphetamines or fentanyl analogs.
Right, controlling the ingredients. And there were specific dates associated with these additions in the text.
Yes, the source material lists specific date ranges, like when these substances were officially added to the controlled list or when regulations regarding them might come into effect. We saw dates mostly in 2025 and 2026 mentioned.
Okay. Whew. That was a deep dive into a lot of legal text, really
Yeah.
covering so many different areas. So bringing it all back maybe to you, the listener, why do these complex changes, all presented under this umbrella of strengthening border security, ultimately matter in your daily life?
Well, because, as I think we've seen, they really do touch so many parts of how modern society just functions. I mean, they affect how companies you interact with every day handle potentially sensitive data about you.
Yep.
They affect how your financial transactions might be scrutinized in the, fight against illicit finance. They change the rules around mail delivery and even the framework governing who can enter or stay in the country and under what conditions. It's far-reaching.
It really does highlight this complex, maybe ongoing effort to update laws that were often written for a very different era, right? Trying to make them deal with digital information flows, globalized finance, evolving security challenges. It feels like it's about the tools law enforcement and security agencies feel they need in the 21st century.
Absolutely. And it really brings to the forefront that necessary public conversation, doesn't it, about how we balance enabling these enhanced security and law enforcement capabilities with protecting individual privacy and rights in these increasingly digital and interconnected spaces we all live in.
Yeah, finding that balance. This deep dive really shows how seemingly targeted legislation focused on borders can have these broad, almost cascading effects across multiple legal domains, changing the rules of the road for individuals and businesses alike.
Yeah, the modern concept of, quote, national security or border security just isn't about a line on a map anymore. It involves managing these complex flows of information, money, and people, and that seems to require these broad legal frameworks to govern them effectively, or at least attempt to.
So as we wrap up, let's leave you with maybe a final thought, something to chew on, drawn directly from the source material we explored today. Consider that new Supporting Authorized Access to Information Act. Think about its requirement for electronic service providers to facilitate lawful access when authorities have the right warrants or orders.
Right.
And ponder that crucial exception we discussed, where they are not required to comply if doing so introduces a systemic vulnerability or prevents fixing one. How does this new law actually attempt to navigate that inherent tension between needing security access for investigations and needing robust digital security for everyone? And, maybe more importantly, what does that specific balance point, that exception, mean for the real-world security of your own online data and communications?
Definitely something to think about long after this deep dive ends. Thanks for exploring these sources with us today.